Okay, today's professional education is on guardianship and public administration with Jackie Miller. Jackie received her Bachelor of Social Work at Missouri State University and began her career with the Missouri Children's Division. While there, she was a foster care case manager, contract oversight specialist, and family drug court liaison. In 2016, she became the public administrator for St. Charles County. She is currently a member of the Great Rivers Region Crisis Intervention Team, a member of the Multidisciplinary Team for Elderly and Disabled Abuse Cases, and serves on various committees with the Missouri Association of Public Administrators. Jackie's married with 2 adult children and 2 dogs. When she's not spending time with her family, she enjoys gardening and photography. So without further ado, Jackie, go ahead and take over.
Everybody. So today I am doing a webinar on public administrators, guardianship, how to obtain guardianship. And I will go through the different slides. I'll have a discussion. I'm not used to webinars, so please forgive me. I'm used to doing everything in person. So if you have questions, throw them up on the chat. And as we go through a couple slides, I'll stop and kind of have a discussion. I try to integrate different stories as they pertain to the various slides that we have. So I'm going to go ahead and share my screen. Okay. So the purpose of this is I will explain the duties and responsibilities of what I do in my office, how relate to how we work with multiple agencies to help the individuals that we serve to be as independent as possible while providing oversight to help shield them from harm. So I'm going to start out real quick with power of attorney. There is a difference between power of attorney and guardianship. Guardianship, you are appointed through the courts, whereas power of attorney, the individual appoints that person to represent them, whether it be financial or for medical decisions. As you can see, it's an estate planning tool and it's executed in order to delegate someone to act on behalf of another person should they become unable to do so. There's 2 common types, which are the medical and financial. It must be executed while the person is competent. They don't lose their right to act on their own behalf by appointing a power of attorney. There's no court supervision, and that person can change their POA at any time. A guardian, there's a couple different forms of guardianship. There's the full guardianship where the person is appointed by the probate court to have custody of a minor or an incapacitated person. As public administrators, we're only guardians for adults, so that's 18 and over. Then we have a limited guardian, and that is a person whose powers as guardian are limited by the court to certain specified functions. And I'll go into a little bit more detail a little bit later. Then you have conservator. Conservator is over the finance, whereas the guardian is over the person. So a conservator is a person or corporation appointed by the probate court to care for, have custody of the property, and oversee the financial affairs of a minor or a person with a disability. So unlike guardianship, with conservatorship, the public administrator can be appointed over a minor in that situation, not so only over their finances. And then a limited conservator is a person whose duties and powers are limited by the court. So, and I'll go into a little bit more detail on that as well. I'm just trying to go over terms real quick. When you go through the probate system and you're appointed as guardian or conservator, the judge has to determine if the individual is incapacitated or partially incapacitated. So these are the definitions that judge goes off of. So an incapacitated person, it's a person who is unable due to any physical or mental condition to receive and evaluate information or to communicate decisions to such an extent that he is unable to provide himself with food, clothing, shelter, safety, or other care to such an extent that physical injury, illness, or disease is likely to occur. So the biggest thing that we're kind of facing now is a lot of family members, sometimes medical professionals, they'll approach about getting a guardian, whether it's a public administrator or if it is a family friend or a family member. The biggest thing that we're seeing right now is the families don't like the choices that the individuals are making. That is not the case for a guardianship. That is just unfortunately the choice that the person is making. If they're incapacitated and they're making poor choices, then yes, that does lead to a guardianship. If they're just capacitated and they're making poor choices, that's just unfortunately what that person is choosing to do. And it does not mean that that individual needs to have a guardian. So I'm really looking hard on some of those cases when they come across my desk to really decide, is it that they're making poor choices, or is there really some sort of incapacity? If they're if I don't really see an incapacity in there, I'll question who is petitioning, just so that way we have all the evidence prior to going to court. Then you have a partially incapacitated person. It's a person who lacks some but not all of the abilities necessary to provide himself with food, clothing, shelter, and other essential care. The ward is defined as a minor or incapacitated person for whom a guardian or limited guardian has been appointed. I don't typically use the term ward. I usually use the individual that I'm serving, or I call them by their first name unless I'm in public, and then it's the individual that I'm serving. Least restrictive environment. It's the legal requirement that an incapacitated person liberties should be limited to the minimum necessary to prevent him from injuring himself or others, and which provides him with such care, habilitation, and treatment as is appropriate considering his physical and mental condition and his financial means. And that's something else that we'll talk about shortly. So the process of starting to gaining guardianship is the petitioner. It's the person that feels that the individual needs to have a guardian. They will obtain legal counsel. Once they do that, they will contact probate and a hearing will be scheduled. When that happens, a guardian ad litem is appointed for the individual that they are wanting to consider having a guardian for. And that individual typically will meet with them at least one time to talk to them about all the proceedings, kind of letting them know what's going on, see if they understand what is going on, and if they feel that they need to have a guardian. The petitioner is also responsible for getting the interrogatories, and the medical interrogatories. It's a series of questions by a medical professional that will determine whether or not that individual is competent or not competent. Then we go for the hearing, and all the evidence is presented, testimony is heard, and then a judgment is made. And when the judge decides on his judgment, that's when he will determine whether or not it's a full guardianship or limited guardianship. And he will often ask the petitioner, and if the medical professional is there, what they feel is necessary for that individual. Then they will also talk about what the least restrictive environment is for that individual. And so usually the petitioner will present evidence as far as why they feel like nursing home may be beneficial for the individual, or continue to reside on their own, or somewhere in the middle. And then the judge makes his determination and will point out what he feels is the least restrictive environment, and then determine if it's full guardianship, full conservatorship, or limited on either. Does anybody have a question in regards to the process of gaining guardianship? Okay, moving on. So the petitioner will obtain legal counsel. So they'll gather, like I said, they'll gather the necessary documentation, they'll file the petition and supporting documents. And then probate will ensure that all notices are sent out to the interested parties. This is not necessarily a fast process. This can take a couple of months to do. They do have emergency guardianships. And when you apply for emergency guardianship, my commissioner is really focused in on what is the exact emergency. If they are in a setting where their needs are being met and they're safe, and somebody just wants to have the guardianship done quickly, that does not meet the statutes for an emergency guardianship. If they're in the hospital and they are incapacitated, they need to have a surgery and it's imminent, then the judge will determine if that's an emergency or not. And then from there, he'll proceed with an emergency guardianship. Usually after the emergency guardianship, about 30 days later, they will have a full guardianship hearing. Not for full guardianship, but it's the actual just guardianship hearing to determine if it's limited guardianship or full guardianship. So I had mentioned that an attorney is going to be appointed for the respondent. That's known as the guardian ad litem. And like I said, they meet prior to the hearing. And sometimes they could decide that they do agree to the guardianship. We still have to have the hearing. They can waive their rights to appear in person or not, and then that guardian ad litem would represent them in court. They make sure that they know and understand the process. And then they also have the right to a jury trial, or they can waive their right to a jury trial. I have been in this position for 8 years. I've had one jury trial, and that was a lot different than a regular hearing. And the jury got to decide on that situation, on whether or not the individual needed a guardian or not. So during the hearing, the respondent has a right to be represented by an attorney. I've had it to where they have fired them and then they have had to postpone the guardianship hearing, and a new guardian ad litem has been hired to represent them. They can have a jury trial. They can present evidence on their own behalf. They are allowed to cross-examine all the witnesses. They can remain silent. They can have an open or closed hearing. Most of the guardianships are open. A hearing conducted in accordance with the rules of evidence in civil proceedings, except as otherwise modified by law, just means that it's a traditional hearing. They have a right to be present at court, and they can request an independent medical or psychological examination, and then the fees are typically paid for by the county if the respondent cannot pay for the examination. So typically, when the interrogatories are completed, it is by their doctor that they have seen for many, many years, either a medical doctor or psychiatrist. On a lot of circumstances, the individuals are hopping in and out of the hospital, and that psychiatrist will often do the interrogatories based on how often they've seen them and the circumstances that they're under at that point. So the judgment is made, and the judge has several options. And as I said before, he can determine whether or not the person is incapacitated or disabled or not. And that would determine whether a guardian or conservator should or should not be appointed. They have to determine whether or not it's full guardianship for totally incapacitated or partially incapacitated. So who can serve as a guardian and conservator? A spouse can, a parent, an adult child, an adult sibling, another adult, close adult relative, a non-family adult friend, or a public administrator. So the first four do not have to go through the background checks or the credit checks. The next two, the adult close relative or the non-family adult friend, they have to go through a credit check and a background check. And then the public administrator is of last resort. You will very rarely find us going and petitioning the court to become guardian over an individual. We have done it, but it's very, very rare. Whenever a case comes across my desk that they're asking for me to be the guardian or conservator, or an attorney calls me, I always ask about other family, and I inquire where the family lives, how close they are, why they would not be able to serve as the guardian or conservator. And I just start asking those questions because I want to make sure that I am the last resort. And kind of the spiel that I always give to the attorneys or the families when they're saying, nope, I don't want it, I can't do it, I've tried to help for many, many years and it's not possible anymore. I always explain to them, if I'm appointed, they no longer have a say. They don't get to decide where the person lives. They don't get to decide if they can visit, if they can't visit. They don't get to decide any medical decisions. All of that falls on me, and they give up those rights. So if they are not ready to give up those rights, then they are the ones that need to proceed with obtaining guardianship. Okay, so all of the statutory responsibilities fall under the revised statutes of Missouri in 475. According to Missouri statutory law, a guardian's duties include, but are not limited to, the following: that we have to ensure the ward resides in the best and least restrictive setting reasonably available, assure that the ward receives medical care and other services which are needed, promote and protect the care, comfort, safety, health, and welfare of the ward, provide required consents on behalf of the ward, exercise all powers and discharge all duties necessary or proper to ensure of all the functions to be carried out. So the ward residing in the best and least restrictive setting, reasonably available. Placements are hard to find right now. And whenever I get an individual, if they have been coming and going a lot from various places, causing some problems, possible some criminal activity, the judge sees all that, and like I said, he gets the recommendations from the medical professional and the petitioner on where they feel like the least restrictive setting is. Oftentimes, they've had a level 2 and it's going to be in a nursing home. So that is typically where some of them start out. And I'll kind of talk about this as future goes. My goal as a guardian, and I explain this to every individual, whether or not they're listening or understanding it at the very beginning or not, but I also reiterate it every single time. My goal is to give them the most independence that they possibly can have and or restoration. And I've recently started a different program with that, and I'll go into that as we get into some of the different placements that we have for the individuals. Okay, what is a public administrator and what do we do? So, public administrators were started in 1880, so we've been around for quite a few years. Most of the public administrators are elected every 4 years. Out of the 114 counties plus the city of St. Louis, there are, I believe, only 4 of us that are appointed. So I am appointed every 4 years, and our presiding judge is the one to determine if I'm hired or not hired and can be reappointed. We have to follow the state statutes of the probate code, which is primarily the 472 and 475. We provide protective oversight and substitute decision-making for the residents who are medically and legally determined incapacitated or disabled by probate court. We are appointed as a last resort for the individuals that we serve. That's the majority of our duties, is falling under the guardianships and the conservatorships. We are also appointed to administrate decedents' estates. So if somebody passes away and they have property, whether it's money or personal property, a house, that type of thing, and there is nobody, maybe they had a will, but that person isn't around anymore, maybe they didn't have a will, and they have property to dispose of, and there is nobody around, the courts will appoint us to handle those decedent estates. Other times there is bickering amongst the siblings or other family members, and the judge said, we're not messing with that. They'll go ahead and appoint the public administrator to do that decedent estate. Other times it's mishandled by the people that are involved. And maybe there was some financial problems going on that they were not paying the bills or taking the money for themselves. And if the judge sees that, he'll remove them off the case, and then they'll appoint the public administrator. That is typically across the board a very small portion of what we do. So in my county, I have about 25 of those cases. And then the other set of cases that I have is the guardian and conservator for adults. I have about 260 of those cases. And then I have maybe 5 cases where I am the conservator for a minor. To be appointed as conservator for a minor, typically a parent has to show that they mishandled the finances, and therefore I'm appointed. Sometimes they don't respond to the court. They have to do a yearly notice to the court of, this is how much money there is, this is what I've done with it. They have to show proof that it's restricted. And if they don't do any of that, sometimes they're removed, and then I'm appointed in their place. So each office is set up very differently. There are some public administrators in the really small towns where they have under 50 cases, and if that's the case, they are part-time. If they have 50 or more cases, they are full-time. And then it's up to each county to determine how many people are going to support them in their office. So I have close to maybe 285 cases total between my decedents estates, minors, and then the guardianship and conservatorship. My county, I have one full-time deputy public administrator, and that is my case manager. She helps me go out on visits with people. She helps me with my annual reports, attending their meetings, and then assisting in any other area that I have. I have a part-time public administrator who handles all of the food stamp applications. She handles Medicaid applications, and then she helps to reconcile probably half of the bank accounts that we have. The case manager reconciles the other half. And then I have another deputy public administrator that handles all of the room and board invoices, the personal spending. She handles the Medicare and Social Security. And then there's me, and I do all of the settlements and the annual reports. I handle going out on visits. I am the one that tends to put out the fires that are going on. I work with the personal representative cases. So that is kind of the dynamic of my office. You'll see it differently in other offices where maybe they have a designated caseload, or maybe they have somebody that just does settlements. Each office, each public administrator can choose to set it up however they want. This is what works for my office at this point in time. All right, so guardianship versus limited guardianship. If we get full guardianship, that does not mean that it has to stay full guardianship. I am always assessing the individuals to see if there's something that they're gaining understanding on to be able to give them that right back. So under a full guardianship, they lose their civil rights. They lose the right to make decisions about most aspects of their life. They lose the right to vote, drive or obtain a driver's license, to get married, to make enforceable contracts, and they lose the right to choose where they live. In a limited guardianship, they may retain some civil rights. They can retain to make some of their decisions about their life, retain the right to vote, drive or get married, enter into contracts, or to choose where to live. So some of my individuals, it may be that they have a limited guardianship in that they're only retaining the right to vote, or they can make minor medical decisions. So if they go to the doctor's office, they can make any of those decisions. But if they go to a hospital, that is where I have to step in and make those decisions. So that's kind of the difference between the two. And like I said, I'm always assessing to see where they are. I have several right now that are asking for the right to vote again. And so we've had conversations about it. They seem to understand that whole process. They understand why they would want to vote. So I am going to be petitioning the court for them to have that right to vote. Does anybody have any questions so far on limited guardianship versus full guardianship, or anything else that I've said?
Hi there. I'm so sorry I cannot put my camera on because I'm wearing a hat working from home today.
That's okay.
This is Lisa. I also work at Voice.
Okay.
You talked a little bit ago about the restoration of rights.
Mm-hmm.
Can you give a percentage as to how many people try to restore their rights, or you help to restore their rights that they're actually given back? Because we keep hearing that it's really almost nearly impossible for people, once they have any sort of guardianship, to regain some of their rights.
So again, it's really up to each guardian on whether or not they're going to pursue it. All of my individuals that I have, let's just round up. I have 275 individuals. I would say probably if you ask 200 of them, they would say that they want to have their rights restored. So we talk about what that means. And I just started 2 different programs. One is a step down program that's going from a nursing home to something less restrictive. not typically completely out on their own. It's typically to an assisted living home or residential care facility, or if they came from the developmentally disabled side into an independent supportive living. So the first step with that for them stepping down, it's just to gain some more independence. I made up a mental health evaluation and physical health evaluation. I want them to tell me in their own words if there's any physical diagnosis that they have and or mental health diagnosis that they have. I want to see their insight into it. If they have a decent understanding that, yes, I do have this diagnosis, this is what it means, I understand that I have that, then we kind of start progressing to, are they doing various things to show involvement at the facility where they are? Are they complaining about their medications? Are they taking their medications? Are they eating? Would I have any concerns with them stepping down into something less restrictive and going completely off the rails? If not, we move them in that direction. Once they're in that less restrictive facility, so it's either an independent supportive living home through developmentally disabled board, or it's through an assisted living facility or residential care facility, that's when I start the restoration of rights. It could be more independence, it could be full restoration. My program, it is not set in stone, but it's about a 3-year program. But again, I have other people that I've just started in this program and they're starting in phase 2. So they've like skipped the first year. And with that, again, there's a mental health and a physical health evaluation because I want to see, do they understand their mental health? Because my goal is if I restore them, I don't ever want them to come back under guardianship. I want them to be successful. When I have seen people come back under guardianship when it was a restoration that probably should not have happened, I have found that they wind up in a worse situation than where they were to begin with. And I don't want to see that. So I try to get them as independent as possible. And if it's restoration, I want them to recognize the signs of when they may be slipping and know where they need to go for help. I want them to have built up their natural support system. So you had asked, what's the percentage? I, on average, restore 1 to 2 individuals a year. It just kind of depends on where they are. My hope is that that number could increase, or I could increase the restoration of some rights since I just started this program. I've always done something, but this time I'm actually putting it in writing and there is a tracking system. Whereas before I just kind of monitored it myself without anything in writing to track. So did I answer your question?
You did. Thank you very
Okay.
much. That's more than I thought, because I thought with Missouri's court system, they really like guardianships, and I thought it was closer to 0. So, so that's encouraging. Thank you very much.
No problem. So I think that's where we're here to educate. And I can't speak for every county. I can speak for this county. Our judge really looks at the reason behind it. And he has to have that medical interrogatory to determine whether or not they need to have a guardian. I know there's talk about supportive decision making, and Missouri supposedly has it. From my experience, there's no court order for supportive decision making. It's just basically goes back to that power of attorney. Is there somebody there to help you make decisions? And it can't be paid staff. So some of our developmentally disabled individuals that are in ISLs, they can't rely on the staff that are there to support them day in and day out to help them make those decisions. They have to have some of the natural supports. So that's what we kind of look at, but I'm trying to educate as many people as I can that if you don't need a guardian, we don't want you to have a guardian. It is a huge change, and it takes a lot for somebody to come under guardianship. It doesn't seem like it does, but that doctor has to be able to say they can't do it. And so that's huge. And the judge has to find that doctor was right. But like I said, we're trying to educate people on that and show that we are kind of trying to move in the direction of restoring rights as they can. The next one is conservatorship versus limited. Again, conservatorship is over the financial aspect of everything. Full conservatorship is we are over everything, all of their finances. We have to know what's going on with that. And then limited conservatorship, it may be that they have control over maybe their work paychecks or some sort of, 401k that they may have. It's just kind of dependent on what they understand and what they're able to do. So part of the conservatorship for me in my county, we have to do an annual report to the court once a year. So one part of it is a status update. We have to talk about where they are, what they've been doing. Are they able to be habilitated? What kind of stuff have they done for habilitation? That type of thing. The other part is a settlement. And that is a full financial breakdown. I have to show all the money that this individual received and how it was spent. I have to provide ledgers. I have to provide canceled checks, everything for that individual. So the probate court audits me in that. Then I also send all of that to my finance department. They audit me on that as well. And then on top of that, every 2 to 3 years, Social Security will audit me. And then every few years, my county auditor will audit me. So I have a huge checks and balances with everything that I do in regards to their finances. So some of the complaints that I get, and I've had to instill some of these new stipulations because I've been through Social Security audits and they have said, we need you to change this to A, B, and C. So some of the complaints that I get when the individuals are in nursing homes is that they're not getting their personal spending. I have to have a log from that facility or from that individual if they're capable of doing it, showing that they received their last month's personal spending and how they spent it. If I don't get that, Social Security has told me I can't send the next month's personal spending. So a lot of times they'll reach out to Voice or some of the other ones, some of the other state agencies to complain that I have not been providing them their personal spending. And usually that's the reason, is that I have not received that log, so I can't give the next month's personal spending. So we keep track of all of that. Let's see, placement for individuals. So we have community placement with support. So that is just out in the community and they're living in their apartments and are in St. Charles area. We have Compass Mental Health that can provide them with a lot of the supports. I don't typically start my individuals out in this type of placement because typically by the time I'm getting them, the family has had guardianship of them and they can't do it, or I'm getting guardianship of them from the hospitals and they have been in and out of the hospital and they have pretty much kind of failed at being able to live in the community. So again, that's kind of another educational point that I want to make to a lot of people is that the individuals that we are typically getting are some of the individuals that have not been on medications for many, many years. And they are just kind of wreaking havoc. We're in their community setting. Most of them do not believe that they have a mental health problem. Most of them don't feel like they need medication. They feel like they are just like everybody else and that they can do whatever they want, but they're in and out of the hospitals quite a bit, or maybe they're in and out of jail quite a bit. So typically those individuals I can't put back out in the community because they were not successful. So I'll start them at a higher level and then work their way down. Another setting is the independent supportive living. So it's also known as an ISL. Those are only for individuals with a developmental disability and they have to have a waiver. These are homes in the community that they may live with 2 to 3, 4 other people and they have 24/7 care. Then you have residential care facilities and assisted living. Those are very, very similar. Typically, your residential care facilities will take the individuals on the income that they have, whereas assisted living, it's private pay, and they have to have just more assets. And typically, the individuals I get do not have a lot of assets. Then we have nursing homes. and then the state mental health hospitals, which we only have a few of those. The nursing homes, again, that's not necessarily an ideal location unless it's an older individual that has some physical needs that need to be addressed. They need help with their ADLs. They may be having dementia. Those are my perfect examples of going into a nursing home. Unfortunately, we don't have any real behavioral health settings. So some of the nursing homes, as you guys know, are kind of switching over now to helping out with the behavioral health end of it. And those are typically the individuals that I get that are coming in off the streets that have been in and out of jail and out of the hospital. They don't feel like they have a problem. They don't believe they need the medications. They're doing self-harm. They may be assaulting other individuals. I usually end up having to put those individuals into a nursing home. The state mental hospitals, they're forensic, so they have to commit a felony, and DMH has to evaluate them to determine whether or not they are incompetent to stand trial. And if they are, they go into the state mental hospital. So as I previously talked, the goals of a guardian is to work with the individual to become independent as possible. Again, that does not necessarily mean that they will have full restoration. It could mean that they've learned that how to vote. So I restore that right. It could mean that they understand now how to call a doctor and to schedule a doctor's appointment and be able to make dental appointments and decisions on their dental or minor medical. Then we restore that ability to do that. We connect them with services. A lot of the individuals that we have, they have been attempted to connect with some services. Some families have never connected them. So if they have a developmental disability, I always have them evaluated if they don't already have a case manager. And I work with my local SB 40 board to find out if they meet the qualifications for the developmental disabilities. Mental health programs around St. Charles area, we have Compass Health. In the St. Louis area, it's BJC, and Compass is now in part of that area. We have day programs for the individuals to get involved in, and employment services. My typical individual, if they are not of retirement age, I want them involved in something. I really try hard for them to be employed if they can be employed, whether that's a sheltered workshop or in the community with voc rehab supports. If they can't do that, then they are in a day program. I try not to have them at home with idle hands. And then we also work on restoration of rights, which is full guardianship or limited. And then to be restored, they no longer need the guardian. All right. Anybody have questions? Want to hear different situations that I've been involved in to make some of these decisions for the individuals?
We've got one question in the chat that says, are you able to speak to how a family guardian would manage these audits? And do they need to be prepared to retain legal counsel to file reports each year?
So as far as a family guardian, they're not subject to the same reports that I would be subject to. So if they have a lot of assets, the judge will have them do an annual settlement. I have software that handles mine for me, but they can do an Excel spreadsheet, they can do QuickBooks, they can write it down on a piece of paper, just showing money in and money out, and then attaching bank statements. So they just have to be organized to the point that they can be able to show what they have done with the money, that they have not been exploiting the individual. They do not need to have counsel to submit those reports. They just mail it into probate. Probate mails out a form every year for the status update. They just handwrite it, and then they provide their settlement back. If it's just Social Security that the individual is receiving, they can ask for no further process. And that just means that they don't have to report to the court on how the money is being used. However, Social Security wants you to fill out something every single year on how that money was spent. So you'll have to do a report to Social Security, and they send you the paperwork on that as well. And so you just complete it showing how much you saved for the individual, how much you spent on the individual, what it was used for, and then they review that to determine if you're doing a good job or not.
All right. I'm not seeing any other questions. If anybody has any more, go ahead and type them out now. I'm going to share just my screen again. So this is Jackie's email. If you guys want to take a picture of that, write it down really quick. If you have any further questions or any specific situations you want to ask about, feel free to send her an email. And please take the survey after you close this out, and you'll receive this recording and the slides in your email within the coming week. Let me just check again if we have any more questions. I'm not seeing any. Jackie, thank you so much for all this information. Yes, I will put up that email again. Here, let me go back. There you go. I'll leave that up for a minute. Jackie, we appreciate all your insight. And yes, it was a really great presentation. Thanks, Alex. So thank you so much, Jackie. And yeah, let's see. Hold on, I got one question. Have you ever had a senior living community request a guardianship?
I have. It's here and there. A lot of times, if the family has not been involved or the senior living facility has concerns about the family, they will ask for a guardian. And at that time, I have them talk to their legal team that they typically have. Then they talk to the doctors about getting the interrogatories, and then they appoint a guardian from there. It's typically when they notice, the ones that I've had, it's typically when they're noticing that the individuals are having some medical issues that they're not quite understanding anymore. And they don't really have anybody to reach out to help them make some of those decisions, like no family around, that type of thing. So that's when they'll typically reach out to me. Other times it could be because the family stopped paying the bills and the individual has no idea how to pay the bills. Then they'll reach out to me to request a guardianship or conservatorship.
All right. Yeah. Sorry, just checking if there's any more.
Nope, you're good.
I am not seeing any more. So I think everybody's got the email down. And again, Jackie, thank you so much. We really appreciate your expertise on this. And like I said, I will be in touch with all of our attendees soon with this recording. So I will go ahead and close out now. Thank you all.
Thank you.